Morning, everyone. We are ready to get started in just a minute. While you are entering into the webinar with us, please feel free to add your name and agency to the chat below. We will be using the Q&A specifically for questions during the training. Welcome. My name is Jody Weiner. I am the Learning and Development Specialist here at SSF. I will be your moderator today. I am joined by Minyoung Shin from Legal Services of Northern California and Avantika Rayo, I hope I'm saying last name correct, with Project Sentinel. This is the first time. Actually, I really want to celebrate this and elevate their collaboration. This is the first time we're providing a fair housing training in collaboration with both organizations. So thank you both for setting time aside to provide our community with what is happening with fair housing in 2025 and what we all need to know as providers, as community support staff, everyone who is joining this training. And for those of you that are here as participants, thank you for setting aside the time to be here to expand your capacity so together we can all work towards resolving homelessness. As I mentioned when we began, please be sure to use the Q&A function only for your questions. We want to be able to make sure we have time at the end of our 90 minutes to support all your questions. If they get dropped into the chat with over 300 or 400 folks, we're going to lose your question, and your questions matter to us. We read them all. So with that, I will get started and turn the mic over. Hold on, one more housekeeping thing. Of course, all of our trainings are recorded, closed captioned as well. I will tell you that a feature in Zoom that many didn't know, when you hit the closed caption, you have an option to select language. So you can translate it to a different language if you so choose. And with that, I will now turn it over to Avantika with Project Sentinel.
Hello, everyone. I'm Avantika Rao with Project Sentinel, Fair Housing Staff Attorney. Thank you so much, everyone, and welcome to this wonderful interactive training sponsored by Sacramento Steps Forward. I'm so glad to see that this is being broadly attended. Our goal is to really empower the folks like you guys who are in the front lines of seeing the diverse populations with housing needs coming into your service centers every day with all sorts of questions and giving you the information about the protections that are on the law, on the books, some of which may not be being respected by housing providers, and how you can ask really pertinent questions to find out more information and potentially do your own Google searches, do your own searches at the law libraries that you have in your neighborhoods, and also be able to collaborate with local legal providers such as Project Sentinel and Legal Services of Northern California to get more information and referrals and potentially advocacy. So our goal is really to give you the information to empower you to be basically quasi-legal advocates. Now, I would just caution you that although we're going to go into a lot of information, this is all general legal information that's constantly changing, as I'll go over in a second. Next slide, please. So the 5 main things that we do at our Fair Housing Center at Project Sentinel is we go and test housing providers to find out if they're discriminating. And we educate in the community, including everyone from realtors to housing providers, to give them information about the fair housing laws, because they are, as I said, constantly changing. We also investigate and keep an eye on property managers, realtors, bad actors, and find out the facts behind those circumstances. I just want to caveat that with, we don't have the power to remedy just purely negligent, bad property managers. We are really focused on discrimination. So that's like kind of the difference. We also negotiate and advocate. Next slide, please. A little bit about myself. I'm licensed in California. I do have multiple language abilities, and I had a background in sex and labor trafficking, which is kind of at the intersection between coercion and labor and immigration. It's all kind of like lumped in there. Next slide, please. As mentioned at the outset, this is just general information and it's not comprehensive. It's just not possible in a short period of time to go over every possible law. And also, while this information is accurate as of the time that we compiled it, please always do an update and do a Google search. Nowadays with AI, you can find out lots of information. So just make sure that laws have not changed since this presentation, because they are constantly changing. Next slide. So a roadmap of what we're going to go over today is we're going to touch on the intersectional lens, which is really critical to use, because we're going to talk about protected classes, which I'm also really passionate about educating about. We're going to talk about retaliation. In fact, I just wanted to I mentioned that up front, that it occurs all the time. We see it all the time, even though it's technically against the law. It's just one of these things that people kind of, some people tend to think like, oh, if it's against the law, then it shouldn't happen. No, it's happening all the time. And then we're going to go into disability protections, which is about the majority of the types of referrals that Project Sentinel gets, actually, is requests for disability accommodations and protections. Then I added a section on protections for LGBTQ populations. That is primarily California based because of the federal rollbacks. And we are also going to talk about crime survivors. And I just want to flag for you guys that we should also incorporate crime survivors into our intersectional lens with which we view all of these kind of people that come into our offices, because that is also a fair housing analysis. Because so if a person is undergoing some sort of interpersonal violence or human trafficking or elder abuse, it is the intent of and spirit of the California laws to give them all sorts of protections from discrimination. Next slide, please. So this slide is to kind of talk about the intersectional lens, which I think is, like I mentioned, is absolutely critical, because we ourselves come to this work with our own little fishbowl that we've been raised in that contains our own biases, and we constantly have to filter through those. Our learned biases, our confirmation biases, what people have marketed to us about various populations, and then we have to kind of screen that out and look at the person that we are intersecting with and is asking for our assistance, and map onto that our knowledge, our knowledge about programs, and then also try to kind of recognize the barriers, whether they are systemic barriers or social barriers that they're being hampered by. Some of these barriers can include social rejection and over-policing. It can include trauma or substance use, criminalization, and it can include unemployment, ableism, discrimination, just to name a few. And the power of our intersectional lens is, I see it over and over again in the work that I do over the years and decades, is that, for example, just as one example, if we intersect with somebody who is has a child who is stuck in the criminalization cycle of, the child is running away, or I actually had worked with a person who the child ran away, got trafficked by a person that she thought she fell in love with, um, then was arrested for prostitution. The mother started drinking. The mother ended up having a DUI, and it's kind of one of the attorneys that she went to said, go to all these places and get your records, and was really demanding with this parent, and saying, like, you have this problem, the judge is going to be really judgmental about your drinking problem and all of these things. And when she came and met with me, she started crying and said, you're the first attorney that actually didn't make me cry, like, didn't judge me for doing this. And I said, well, it's it's actually totally understandable that your heart is breaking, that your daughter was trafficked, and you're soothing yourself. I don't judge you for soothing yourself with whatever you want to soothe yourself with. And I don't want to create like more trauma and more, problems for you. That my goal as a provider is to actually try to undo and empower you. So we have to see like that, where our place is in the kind of system, and that they're being harmed by these systems. I mean, why would a daughter who was trafficked at age 16 or 17 get arrested in the first place? Right? Like, it's just absolutely ridiculous. So you can see on there how criminalization, discrimination, and her substance use was all tied in together with the oppression that they were facing. Just as one example. Next slide, please. So what are some helpful approaches? And these are suggestions, and I know that we have Housing First standards that are really helpful as well. But practicing having low barriers to our services, practicing being trauma informed. And in being trauma informed, it's really important to do that as a team. So to have trainings on an ongoing basis on how to be trauma informed together, so that you can approach these services with that lens. How to have as many on ramps to services as possible, and then, like I mentioned, to have that intersectional lens where we're constantly filtering out our own biases, and then also recognizing the systemic barriers and other discriminations that they're facing in their own lived experience. Next slide. Oh, thank you so much for the hearts. I see that, and it's beautiful. So the laws, okay, you'll be shocked to learn that a lot of these laws are relatively recent. So in 1963, that's when California, which California was a little bit ahead of Congress in passing the Fair Employment and Housing Act and the Unruh Civil Rights Act. The basic distinction from the Fair Employment and Housing Act and the Unruh Civil Rights Act is that FEHA, we call it FEHA, applies to employment and housing, and Unruh Civil Rights Act applies to businesses. But in the case of most housing providers, they actually qualify as businesses, so you can usually get both protections in California for people who are dealing with housing providers. In 1968, finally, after the death of the esteemed MLK, Congress passed the Federal Fair Housing Act, which was landmark civil rights legislation that a lot of us rely on and as our basis for anti-discrimination work. And then what is also shocking to people is that things like disability was not actually added to the Fair Housing Act until later in 1988. And that's through the Fair Housing Amendments Act. So if you think about how long disabled populations have had their own struggle of, being over incarcerated, being basically like having all their supports taken away and being put in basically jails that they're called mental institutions, and how that struggle has evolved is that finally in 1988, they were added to the Fair Housing Act through the amendments. Next slide. So this is a really key slide. So if you want to take a photo of it on your phone, please do so. On the right, you see California. On the left, you see federal. And so there's, on the federal side, you see race or color, national origin, religion, sex, sexual orientation, that's changing as we speak, gender identity, disability, and familial status. We're going to talk about some of these to give you an overview of what these categories kind of mean as we go forward in our presentation. But what I will say is it is something that I'm still learning about, even like, 2 years into this fair housing work. It is the lived experience of people, so for example, a person who presents as a woman can have a claim that is based on sex. A person who is trans may have a type of claim that is based on sex and gender identity or sexual orientation. It can be multiple categories. On the right is California. We'd have broader protections in general in California, especially with LGBTQ populations. So at the top, you see marital status, then you see age, source of income, which we'll talk about, arbitrary, which is kind of a catch-all for things that are not kind of contained in other categories. You can't discriminate on the basis of being a military or a veteran. You can't discriminate against people who do not have immigration status, who do not use English as a primary language or who use another primary language. And also there's some certain protections for licensed daycare providers because we do not want those businesses to be excluded just because of the basis of we want more people providing home-based daycare. Next slide. If you could go back one.
Thanks for your patience in tech.
Thank you, Jody.
You're welcome.
Okay, so who can ask for an accommodation? So we're kind of getting into the disability accommodations. And disability accommodation is basically an exception. You're asking for an exception from the rules or the practices that a housing provider has. Who can ask for one? And each bullet point represents a type of way that you can intersect with the disability. So you can actually be a person with a physical or mental major life activities, or you can be a person who has a record of impairment. That means you don't even have to have presently a disability, but say you've received treatment for cancer, and now you're a survivor of cancer. That would qualify you as a person who can request a reasonable accommodation. Thirdly, you can be perceived as having such an impairment. Next slide. So this, I believe, I'm not seeing the title, but I believe this is the physical impairment language in the code section. And I feel really strongly about sharing the original language of the code sections with people so that they get a sense of what it's like, what it's like for us unfortunate people that are lawyers. But look how the language is like. Having any physiological disease, disorder, condition, cosmetic disfigurement, or anatomical loss that does both of the following. This is the California language, by the way. Affects one or more of the following body systems: neurological, immunological, musculoskeletal. You get a sense, right? You can read it yourself. And it limits a major life activity. And then if you scroll down to where it says number 3, it says having a record or history of disease, disorder, condition, etc. That's where that language comes from in California. Next slide, please. Oh, there's the physical disability. So that gives you the code section. California Government Code 12926M, if you want to look that up, if you're a sucker for punishment. Okay, mental disability. This is a really broad one as well. So 12926J, mental disability. Look how many things it covers. Intellectual, brain, emotional, or mental illness. But then notice that it actually says that even, I think, I saw it, that limits, okay, see where it says A, limits shall be determined without regard to mitigating measures such as medications, assistive devices, or reasonable accommodations. What that mean is, even if the person is on medication and they're actually, it's well controlled, whatever their symptoms or their are, they're still considered a person with a mental disability. So that's something you should take into account when you're kind of questioning them. I know it might be intrusive to have conversations about like whether they're on medications or what the plan for their medications is with their healthcare provider. But if they want you to be an effective advocate for their housing, you probably need to ask those questions up, and get a release of information signed by them so that you can go into that. Because if you're asking for reasonable accommodation for them, that may be part of the analysis of it. Next slide, please. Okay, this is just a beautiful photo, just to bring us all onto a positive note. Okay. And then, like I said, what is a reasonable accommodation? It is an exception, a change in rules, policies, practices, or services necessary to enable a person with a disability an equal opportunity to housing. And I really like that language of you need the reasonable accommodation to access equal opportunity in housing. And so when you're looking at what we give you as an example later, try to think in your mind of, is this something that I can ask for to give them an equal opportunity to housing? And that's really the analysis we should all be doing. If they need a ramp, if they need a parking space, if they need a second chance to stay in their housing because they have an emotional disturbance that they're on medication for, but they went off the medication, or and they need you to write a letter. All of those types of things could be something that gives them an equal opportunity to housing, right? Because the other person, the person who doesn't have that mental disturbance or doesn't, they don't need those supports, but the people that you serve do. Next slide, please. So there's a kind of a balancing framework in the law that the housing provider does have the ability to deny reasonable accommodations if it's, quote, an undue administrative or financial burden, or if it's a fundamental change to the housing provider's program, or if it's an undue health and safety burden. However, under California law, what I like to remember is that they can't use stereotypes to kind of, to analyze the request for the reasonable accommodation. They can't say, well, mentally disabled people are really hard to deal with or really risky, so it's an undue burden for us to accept this accommodation. That is not allowed in California. Next slide, please. So like I mentioned, I would give some examples, and these are the types of things that we do see in Project Sentinel. I'm sure Legal Services of Northern California sees these a lot as well. And we see service animals. We see emotional support animals in California. There is protective legislation for those. We see requests for transfer of units. We do see extensions of time. I would say that they do need to continue paying rent, or, as if it's a paid rent situation. And then on the right, we do see breaking early of the lease, rental due date change, for example, from the 1st to the 5th of the month. We'll talk about that in an example. We also commonly see people who are disabled needing caretakers or live-in aides. We see second chance requests. we see accessible parking space requests. And just to go into second chance requests, that's the situation that I mentioned where, say, a person has a mental or emotional disability, and say they were on medication that, and then they changed their medication or they went off their medication and had an outburst, or say they were an adult with autism. I actually had this situation happen. I think in Project Sentinel, we've had quite a few of these where an adult or a child with autism has a situation where they physically assault somebody, but it's actually a part of the symptoms that they have is they may not have been getting the supports that they needed. We can request a second chance in that circumstance. Next slide, please, and let me get a drink.
I think these are my slides. Can we go back to the examples really quickly? I just wanted to point something out. So when we're saying extensions of time, some of the things that I see at legal services, I do a lot of direct client work and work with housing authorities a lot. So if somebody is going through a recertification and maybe they are having trouble, right, filling out the documents, that's another opportunity for potentially asking for a reasonable accommodation to the housing authority to say, hey, this person just needs a little bit more time. Could you give an extension? Of course, you don't want to necessarily do that after the fact, right after the deadline has passed. I recently actually had a case where that did happen, and we were able to give him a second chance and an extension of time for his recert. But ideally, you would want to try to get that reasonable accommodation request in earlier. And transfer of units, same thing, right? If you are going from maybe a second floor unit, but maybe their disability, mobility issues, so they want to get to a first floor, that's another opportunity as well. But one thing to keep in mind, if you are working with the housing authority, let's say they have a Section 8 voucher, you do still have to go through the RIFTA process and the housing inspection with SHRA or whatever your housing authority is. So you do have to kind of keep that in mind, but those are all possibilities. Same with accessible parking. If the apartment complex says, no, we don't do assigned parking, they can still change that rule as long as you have a proper reasonable accommodation to say, hey, this person just is not able to walk 5 minutes to their parking spot. They need a spot closer by. They could technically assign spots as well. So those are some examples that I wanted to kind of point out. Next slide. All right. So what would you want to include in a reasonable accommodation request? Number one, explain the disability. You don't necessarily have to give a diagnosis, but you do need to give them just enough to make a connection between, number two, right? Make a connection between your disability and what the ask is. And then you do the ask. There are some questions about whether you need to always have a medical verification. I think it's always recommended because if the disability is not obvious on its face, so if it's a wheelchair user, that's pretty easy. Like the managers or the apartment complex probably have met this person and could tell just from seeing them that they have this disability. But if it's something more, discreet, like a mental health difficulty, that's not going to be necessarily visible on its face. So in those situations, it's going to be likely that the landlord could request a medical verification. Even on the doctor's medical verification letter, you do not have to have a diagnosis, not necessarily. If the client is willing to disclose it, that's okay. But if they do not want to, all the verification needs to do is kind of explain the symptoms enough to make that connection with the ask. After you submit the request, and the request should be in writing, there's not necessarily any magic words you need to use, but I do suggest, writing down that it is a reasonable accommodation request so it doesn't get ignored. The landlord has to engage in what is called an interactive process. Interactive process is a process where you basically talk to each other, figure out what is going to be deemed reasonable, because not all asks might be considered reasonable, because there are kind of balancing that we had to do that we discussed earlier, right? They can't change the fundamental program rules. So, those are things that you do have to keep in mind. So kind of keep an open mind about what would be the ask. If my first ask doesn't work, what's going to be my second ask? Like, how much assistance do I really need? Next slide. Okay, so this is going to be our little first case example. So I'm going to read it to everyone. And if you are willing to do so, write down in the chats kind of what you think what you should do in the situation is going to be. So our client, Jason, receives his Social Security disability insurance benefits on the 3rd of each month, but his lease requires that the rent payments be made by the 1st. As a result, he's been incurring late fees each month due to the timing mismatch. Moving forward, he just cannot afford to continue paying those late fees every month. So what could we do to kind of avoid that late fee situation? I'll give everybody a moment.
Min Young, are you able to see the chat?
Yes, I
Responses,
am.
wonderful. Okay, it's checking. Our tech has been funky, y'all. Thank you.
Okay, I'm seeing some answers, and I think we're kind of getting to the same answer a little bit. So I'm seeing like the two big things I'm seeing on the chats is number one is to ask for a reasonable, accommodation to move that due date. That is something that is possible. So what I would do in this situation personally, I would find out, get some kind of a documentation, something to show that this person is receiving Social Security disability benefits. And sometimes the landlords don't even require proof of it, but I would still have it for myself as an advocate just to make sure that is actually what's going on. I would write a reasonable accommodation letter asking them to move the due date of the rent, right? Maybe just moving it to the 5th of the month. That's going to give him enough time to actually get the money and then issue the checks and not have any late fees. For all of the late fees that we have already, been paying on, we could try to ask for a waiver, but that's not necessarily something that the landlord is required to do, right? Because you are in a lease agreement, and under the lease, you should have been paying by the 1st. You haven't necessarily asked for a reasonable accommodation yet, so they wouldn't have known to, waive that or move that deadline. But that would probably be my first thing that I try to do. The other thing that some folks are saying is maybe connecting the client to a payee service. I think not necessarily, right? Because here, the prompt, our case example, is not that he doesn't know how to handle his finances. It sounds like the problem is that the money is just not coming on the right date of the month. So he's not getting the money until the 3rd, so he's having trouble keeping that up. So just by moving that, deadline, hopefully the rent due date, that's gonna hopefully resolve the issue. But again, yeah, in the very end of the day, if that still doesn't work, potentially a connection to a payee service could be helpful. All right. So, oh, I do see one question in the chat. It's not in the Q&A, but it is a question about would a RA be necessary in this situation, or would it be possible for the client to plan accordingly? Of course, some folks will be able to plan accordingly, but if the money comes in and then you're trying to save up for the next month's rent, that's going to be harder for folks to do. So I think it would just be a lot safer for our clients if we try to do that reasonable accommodation, because then it's right next to each other. There won't be any mishaps with the money handling, because sometimes, things come up and it might, become like a later thought for them to save up the money for the next month. All right. Next question, please, or next slide. All right. So this is our second case example. And both of these case examples are things that I have personally done with my own clients. So that's where kind of these are coming from. Case example 2 is that Sarah receives a notice of termination due to behavioral concerns. Neighbors had reported frequent yelling at various hours, including during the night. After speaking with Sarah, it becomes clear to us that her behavior is linked to an untreated mental health condition. She is now doing significantly better under the care of a psychiatrist and has recently begun taking medication. So she already has a notice of termination. So hopefully we're stepping in early enough, but kind of what would be our RA request in this situation? Also, for folks who are not seeing your chats, it's probably because you're sending it to hosts and panelists and not to everyone. So if you want to toggle that to everybody, then hopefully folks could see your chats. I'm going to give everybody a moment kind of put in your answers if you can. Nope, there's no option for having it to everybody. That is a tech thing that I cannot resolve, sadly. Okay, I'm seeing a lot of chats about asking for a second chance. When we are doing that, what do we think would be important for us to kind of include in that request? Okay, all the chats are getting to the right direction. So yes, we would want to request a second chance here. And when we are asking a second chance in these type of situations, the important thing is to show why we think it's not going to happen in the future. For her, it was happening in the past because it was an untreated mental health condition. Now that she is getting treatment and is on regularly on medication, hopefully that's going to resolve the issue. So we're going to, of course, want to include some kind of a medical verification because that is not going to be something that the landlord can see on the face of it, right? They might just be thinking, hey, like she was okay for 2 weeks, but like, how do I know for sure it has, it's going to change and it's going to stay that way? We need a medical verification. So that would be a doctor, a psychiatrist, hopefully in this situation, writing a letter. It doesn't have to be that we disclose, hey, she had untreated bipolar. It doesn't have to be that. But the doctor, my suggestion would be maybe they write down, she was not being treated by me. Now I'm treating her starting April of 2025. She has started on new medication and treatment, and she has been showing good progress. I do not expect it to happen going forward, right? So the doctor needs to know why you were requesting this. So when I would personally want to talk to the psychiatrist or whoever the doctor giving the verification letter is, explain to them why we need this RA, have them write down exactly what's happening. Doesn't have to be everything, right? It doesn't have to be the full medical record or the progress notes. It could just be one letter where it says, this patient was untreated in the past. I have started treating this person starting this date. I expect progress and improvement in her, mental health conditions because we are doing XYZ treatments. Thank you. And then you can attach that and hopefully your RA letter or the client's RA letter can have a little bit more explanation and that should get the ball rolling. I did have a case like that very recently and we were able to keep the person client housed and he is doing so much better. And everything, of course, a timeline does have to line up. If the person is continuing to exhibit that behavior after we started treatment, it's not going to be as strong of an RA letter. All right. Next slide, and I think it's back to Avantika.
So now, now we're on the final component of reasonable accommodations or disability accommodations. And it is called reasonable modifications. And can people just give me a thumbs up in the chat if everybody can hear me? Okay, thank you. So, so what is a reasonable modification versus an accommodation? And I know they're just really long letters here and long words, I should say. An accommodation is for everything else, but a modification is for a physical change to the unit. So what might that be? It could be as simple as raising the cabinets up. It could be as simple as adding knobs, different types of knobs to cabinet doors. In one circumstance, I had somebody who needed like the type of drawer pull changed, things like that. These can be disability accommodation modifications in rental complexes that you could request. And they're kind of not very costly. So the landlord would have a difficult time arguing that it's an undue burden, right? So theoretically. So the landlord does have a right to approve plans and ensure standards. The reasonable modifications do also include things such as wheelchair ramps or things like that potentially. However, I would say if you're dealing with a wheelchair ramp, you might want to consult with an attorney or a place like an access to a place where they have more resources on like whether there could be a financial assistance for the client or tenant, because those can be costly. I also gave a link to the California Civil Rights reasonable modifications handout in English, and that was published in April of this year. Next slide. Here is a very helpful resource. There is, if you go to www.housing.org/tenants, there are links to PDF downloads that are, the pictures and snapshots are beautifully captured here. And there is one toolkit that I have with me that goes over in detail what we just covered, which is reasonable accommodations toolkit. And then there are other toolkits. So you can either download the PDF, you can also call and request copies of the flyers for your agency. And some of the other toolkits are for addressing housing discrimination against families with children. There's also a criminal records toolkit. So please go ahead and look on that website for resources to download or get mailed to you. Thank you. Next slide. Very important section to discuss in 2025 is the what is happening on the ground with folks from the LGBTQ plus community. And I wanted to include some information about what is the lived reality. And according to one study that was done by HUD, which is the Federal Housing and Urban Development Agency, between 2022 and 2023, which is post-pandemic, the homelessness rate among gender expansive folks increased by 31%, which if you think about it, that's like almost 1/3. So they are more likely to live on the streets. A 2022 study by the Trevor Project found that between 35% and 39% of trans and non-binary youth have experienced either homelessness or housing instability. And that's from Yes Magazine. Next slide, please. So now we address kind of the changes that are happening. And what I wanted to give as an overview point is that the protections under the state of California are much broader and much more robust because the federal government is actively retrenching and rolling back protections. So that first bullet point is that in California, the California Civil Rights Department, which we call CRD, will take complaints of housing discrimination based on sex, gender identity, gender expression, or sexual orientation. And the California Government Code section is 12955. I do recommend that you look it up. It is what I mentioned earlier as FEHA. That is FEHA, is California Government Code 12955. And then at the next bullet point down is what's happening at the federal level. I don't want to go into too much detail because it's very traumatic for a lot of our populations to basically be just completely deleted and stigmatized and punished for just being yourselves, right? but that's exactly what's happening at the federal level, based on Executive Order 13988, which overruled the inclusion that the prior administration had legislated through their federal actions. So we had just started seeing the ability to file discrimination complaints in housing based on not only gender identity, but also sexual orientation. And now that's being rolled back. Next slide, please. So what are some resources? And I wanted to give some resources because I don't want to just, stop with saying, oh, everything's being rolled back. There are challenges happening. So there's an LGBT hotline. There's a phone number. There's translifeline.org, which also has a phone number for folks who are transgender, non-binary, or gender questioning. And then they also have transgenderlawcenter.org, which has resources. And finally, the National Center for Lesbian Rights has I'd recommend actually visiting all of those websites anytime you have folks that are, or for your own knowledge, and start supporting, because we have to be in allyship about this, right? I mean, this is really an emergency right now. So next slide, please. So LGBTQ plus protections, like I said at the beginning, just giving you a snapshot of this. To go into more detail, it is California Government Code 12955 in California, which bans housing discrimination based on actual or perceived sex, gender identity, gender expression, or sexual orientation. So gender expression meaning like whether you choose to express yourself in however gender norms you choose to express yourself in, whatever pronouns you choose best meet your needs, whatever type of clothing. If you want to wear female clothing, but you're not, necessarily have not transitioned yet, that's completely your choice and your gender expression. That is protected under California state law. There may be other protections under what's called public accommodations laws for transgender folks and other LGBTQ minorities. And there are those protections in states like Colorado as well. But just wanted to let you know so that in case you're doing a Google search, you can look up, is there public accommodations protection for trans folks in, Colorado or Montana or California? And the answer in California is mostly yes. Next slide. So that concludes the section on the LGBTQ plus community. I hope that gave you a little bit of information that you can use. We're gonna now go briefly into income law. And there, like I said at the beginning, source of income is a protected category under state of California law. And I'm giving you the code section here. California Government Code 12955 subsection O and subsection P. Notice how it's actually in FEHA, right? Because I remember how I said 12955 is FEHA, right? So in the subsections O and P, they're saying that all legal and verifiable income sources can qualify a person for tenancy, including whether it's child or spousal support, SSI, SSDI, foster support, Section 8, which is also called a voucher, Section 8 voucher. And the basic premise is that if they get a Section 8 voucher, the amount of the testing towards their income must reflect however much that tenant pays towards the rent. It's called, in Section 8 voucher language, it's called the tenant portion of the rent. So if they pay $500 out of a $1,500 rent payment, then they would be expected to have, like, say the landlord standard is they need to make 2 times the rent. then you would say they need to make 2 times $500 or $1,000 in monthly income to be able to qualify. The new protection, relatively new protection, is also mentioned on this slide, and you can Google that. It's called SB 267. And what that basically provides for, but it's quite a long statute. So I would also recommend that you get resources if you need to. But basically, if they are receiving some sort of subsidy, such as a Section 8 voucher or an income support subsidy as their source of income, they're required to provide an alternative means of proving their credit. So they should be able to, for example, provide landlord references of leaving prior housing locations in good condition, or other forms of proving that they must have the ability to abide by the housing provider's rules of payment. Next slide. Can we go back a slide just for a moment? So just on SB 267, I wanted to note that this is new enough that we don't know, like, we've started filing complaints to the Civil Rights Department, and we don't yet know how the Civil Rights Department is going to enforce that rule. That's how new it is. And there's still kind of a lot of discussion amongst us housing advocates about how we can kind of support people. So right now, the point at which we are at is we're at the point where we're educating a lot of housing providers. Hey, there's this new law. It's called SB 267. You may not know about it, but it does require that you provide, an alternate form of proving your credit to folks who receive some sort of income support. Do you think this could be possible? That's kind of what we're at right now. Next slide. So there is certain forms of discrimination that's permissible, right? I know that seems counterintuitive, but it is very important to keep in mind. For example, senior properties are allowed to discriminate based on age. There are some exceptions for live-in caregivers, spouses, etc. And I gave you the code section, so you could look it up, 51.3. Homeless youth are in the California law that they are allowed to have separate housing. Even in FEHA, there are certain exemptions for like religious housing and dormitories and things like that. So you have to, each circumstance, you have to kind of look up in the law and see, is it protected under FEHA or isn't it exemption, So if you want to get help with that process, definitely give us a call or send us a referral. Next slide, please. And what I mentioned in the beginning is that we also, in our intersectional lens, just like we include their experiences and their and barriers that they may face as other groups, including LGBTQ+, they also may be facing intersectional issues with being a crime survivor. So I've given you the code sections here so that you can look it up. So you can do a search, just to give you an example, you can do a search for how can I help a tenant change the locks based on being a crime survivor. You can Google, how can I help a tenant break a lease early based on being a crime survivor in the state of California. And you'll get these code sections, and then you can look up what might be helpful. And sometimes in the law itself, it gives you like what's called a third-party qualified statement that you can just take that language from the code section and have the tenant sign it, submit it to their housing provider for the request. It's actually there in the law. So what protections are there? There's the general protection is that the landlord or housing provider cannot penalize a tenant for summoning law enforcement or emergency assistance when there is the person believing that it is necessary. And it also applies to someone in the family believing it's necessary, or someone who's there present calling 911. That's California Civil Code 1946.8. We use that a lot. This is not something that I really want everybody to know this. It's very common. And it applies just like equally to elder abuse, human trafficking, sexual assault, all of the forms of victimization that happen in our modern society. Additionally, a landlord must change the locks of a survivor's unit within 24 hours of getting a copy of a court order or a recent police report that documents that victimization, or else the tenant may change the locks. So you have the code section there. And like I said, you can also look up, there's provisions on being allowed to break a lease early due to the victimization or crime survivorship. I do want to just give a brief vignette about this and how it actually shows up. So I did assist a family where one of the members of the couple was trans, and a neighbor was, it was kind of a duplex, and the neighbor was very harassing to them, and they took it as making transphobic statements, and they did not end up feeling safe. The family next door who I was assisting did not feel safe living there. They were also did not feel safe receiving mail there because they believed that the other person who was harassing them could be kind of going through their mail, pilfering their mail. So we were able to use the provisions in California law to obtain a break lease early after they provided a brief statement about the forms of the harassment to the housing provider. And the housing provider basically immediately let them out of the lease, and they were able to move. Next slide. And this is one of the concluding slides that we have here, which is that not only are there protections against discrimination, it is also illegal to harass, evict, or take any adverse action against any person because they oppose discrimination. And next slide, please. And as we mentioned in the beginning, though it is illegal to discriminate or take adverse action against anyone who's standing up for their right to oppose discrimination, it still happens routinely. And that's why we're here, to help educate, investigate, test, negotiate, and advocate. So documenting claims, key points, which is common between Project Sentinel and LISNIC, is preserve the evidence, help the clients download and save the proof, help the clients obtain copies of whatever police reports or court orders they may need to request a reasonable accommodation or crime survivor exemption. There's some referral information on that middle point if you want to send us a referral. And you can also be a witness. This is a very powerful tool, is that housing providers can provide a signed and dated declaration and agree to be interviewed. I know it's not a comfortable thing to do, but it could be critical for the advocacy for a person, for example, who has a systemic biases that they're facing. Thank you. And then, like I mentioned, we assist and can help you to file a complaint with HUD or the California Civil Rights Department. Next slide. So that is our overview for today, and the information is going to be shared with you after this presentation. Thank you so very much.
Thank you, Avantika. We appreciate your support as always. We did have a break in here. However, your Q&As have been so robust. we want to continue on because we've got some really important content with Min Young, and we want to make sure that we are able to cover everything for you today as promised. So we're just going to continue onward. If you need to take a break, please remember this is being recorded and you will get a copy of the slides. You will also get a copy of this recording, a link. You'll get a link in your email. Usually are pretty good about 2 to 3 days, business days. So we will continue. Avantika, again, thank you so much. Always so robust with so much information. We are all so lucky this is recorded
You're very
and
welcome.
move along.
All
Yeah.
right. Just moving right along, and we have 30 more minutes for those who are wondering. I am trying to answer the Q&A questions as we go, so hopefully you are either going to get a copy of them or you are seeing them as we're going along. If you have not got an answer for your questions yet, it's just because we have not been able to get to them yet. All right, so I'm from Legal Services of Northern California. I didn't really introduce myself earlier, but I'm a staff attorney there and she, her pronouns. And we do a lot of like direct client services. Typically, our main thing is eviction defense and, advising folks about that process and kind of guiding them on what they should expect at court or kind of how to prevent an eviction from going on their record. So next slide, please. Again, this is not legal advice. This is just legal information. So hopefully you can take it and, run with it, do some searches that you can online. Our LSNC website does have a lot of resources, so you can take a look at them. And I do have a couple, I believe, links in the PowerPoint as well for you to kind of see. But if you go on Google LSNC and then kind of have a question, oftentimes we do have at least a website or two kind of answering those questions, kind of giving you a little guidance there. We're going to talk about habitability and then what the unlawful detainer procedure looks like. Next slide. Starting off with some how to request repairs and, habitability issues that oftentimes come up in your tenancy. Next slide. Okay, so habitability is essentially saying that when you are leasing a premises, the place that you are living in needs to be habitable. But that does not necessarily mean that every repair item that we see around a house needs to be addressed by the landlord. The reason for that being is under the law, you kind of have to think of habitability as two buckets. One bucket is going to be the building code. So whatever the building code is for your area, the California law, that's going to be one bucket of things that the landlord always has to provide, even if it's not on your lease agreement. The other bucket is going to be for things that are part of your contract. So for example, you can see on this slide, these are the things that the actual building code itself requires a landlord to provide. So if the place that you are living in does not have effective waterproofing, plumbing, gas, heating, electrical systems, your floors are all, lifted, there's, hazards, the railing is falling off, all of those things, not having a working heating system. That is things that the landlord has to provide under the building code. So even if it's not explicitly stated on your lease, that should be provided. The tip for, all of the habitability things, take good photos. Having good records is very, very important. If you end up being in a court situation, or maybe you want to sue the landlord for the lack of habitability, then you need to have evidence, and that's going to be oftentimes photos, okay? Next slide, please. So you can see that requesting, all right, I'm a little bit, my slides have been a little mixed up, but requesting repairs. Kind of going back to what I was saying. So one bucket is going to be that the things that the building code requires the landlord to have. The other bucket is going to be things that are part of your contract. So as part of your contract, something like an air conditioning unit, weirdly in California, that is not required for a landlord to provide you. But if your air conditioning is breaking, that is something that the landlord should fix because that's part of your contract. As part of your lease agreement, the landlord had agreed to provide you with air conditioning. So if the air conditioning is breaking, you have like a breach of contract claim, but that's not necessarily a habitability claim, because habitability is going to be about that building code, and the building code does not force a landlord to give an AC unit for you. The only thing required is really the heating. Air conditioning is not required, like I said. So when you are requesting repairs, a couple of things you want to do, of course, as all lawyers will tell you, do things in writing. So when you are requesting a repair, do it in writing. If you have a portal, that's perfectly fine. But some portals I know does not actually save your request. There's no way for you to go back. So maybe taking a screenshot, right? Keeping a copy of what you submitted, when you submitted it, that's going to be really important. Another thing that you might want to do is, if you think that the landlord is not going to look at your letters, you're worried that they're just going to ignore it and pretend like they never got it when you do a physical letter, you could do certified mails to make sure that you have proof that they did receive it. But keeping all of that is going to be important, making sure that you're actually explaining to them what is the repair that you need, being specific, maybe attaching photos, right? All of that is going to be for your record. Then the landlord has a reasonable amount of time to respond. The law does not actually tell you how many days reasonable is, because reasonable amount of time changes depending on the situation. Typically, we would say 30 days is reasonable, but like the example kind of says, if it's 40 degrees outside and you do not have heating in your house, it's going to be more reasonable to expect an earlier response. 30 days in that situation would not be reasonable, but that reasonability is going to be something that a judge and, when you go to the court is going to be the one to decide. So when you are doing it in your own lives or with your clients, you're kind of going to have to gauge, okay, how urgent is this? How important is this for me? How hazardous is it for my health and safety? And again, the landlord does not have to deal with all of the repair issues. So carpet, paint, those things might not actually rise to the level that the landlord has to, repair. And it will not protect you from an eviction if it ends up getting to that point in time. Next slide. All right. So now that you've actually asked for a reasonable accommodation, I'm sorry about that. I was talking about that for a while. Now that you've actually asked for a repair, but the landlord has not responded, or maybe they did respond, but the issue is not actually fixed. What are your options? Next slide. Like I earlier mentioned, reasonable time, you do need to give that to them. So make sure you are doing, giving them some time to actually address the issue. I usually like to let our clients know, hey, maybe wait a week or two and then follow up. In your follow up, you also want to do that in writing. I always suggest writing something like, on this date, I asked for a repair regarding this issue. I haven't heard from you, or maybe you have, but they haven't come by. You kind of want to explain what happened and then ask, hey, like, I'm just following up. When should I expect to hear back? So you do want to at least do one follow-up before going through the next processes. Each case is going to be really different. The options I'm going to go over, I'm going to have my recommendations, but of course, depending on the situation, what is the best decision for that family? You would have to kind of do that analysis separately or seek legal assistance. Next slide. Okay. All right. After you do the request, nothing happened. My first recommendation after doing at least one follow-up is going to be to call code enforcement. Again, this is going to be for things that are required under the building code, not the things that are in your lease agreement. So if it's an air conditioning thing, code enforcement is not going to care unless it impacts your building code violation type things. So code enforcement, you can contact them in Sacramento County, and I believe most counties, by calling 311, and they'll come and inspect your home and kind of do an analysis. Is this actually a violation? How severe is it? If it's something that is fairly small, then the code enforcement might just talk to the landlord and say, hey, you should fix this by this date. If it's something a little bit more severe, they might even do a formal citation or fine the landlord. Or at the very, very other side of that is going to be, if the building is so in terrible condition, very serious violation, very serious repairs are needed, then they might even red tag the building. I do not see this very often, but it does happen. And that essentially means when it's red tagged that no one can be there. So the tenant cannot stay there. There's no way to fight that, unfortunately. So you do have to kind of keep that in mind depending on the conditions. But I personally have not seen that happen. Even when there's like a fire in the unit, I have not necessarily seen it get red tagged. So, you know, take that and just kind of figure that out for that particular scenario. Then the other option would be to do something called a repair and deduct. Personally, I do not recommend this for my folks just because there's actually a lot of steps that you have to go through. So this is when the tenant fixes the actual issue and deducts the cost of repair from the rent. So as you can see, there's steps to this. So first, you should have reported it to the landlord, given them time to try and fix it. And then the repair that you are doing on your own cannot cost more than 1 month of rent. So if it's something that costs more than 1 month of rent, then you cannot deduct more than 1 month of rent. So I don't know if that would be the best scenario. You could only do it once a year. So that's another thing that you have to keep in mind as well. And the tenant cannot have been the one to cause the damage. And this is for serious defects only after you ask the landlord to fix it in a reasonable time. So if your heating goes out and the landlord's not responding and you are in, very cold winter, then yeah, maybe it is something that you want to do to keep yourself safe while the landlord's not responding. But it is something that I warn against generally, because if you stop paying rent and pay a smaller amount, there is always a risk that a landlord gives you a 3-day notice. Even if it's something you followed the law and did it correctly, you still will have to fight that 3-day notice. So that might be a challenge that maybe the family does not necessarily want to go through. Next slide. Withholding rent. This is something that does come up fairly often for my clients, where you end up withholding rent because the repairs have not been completed. You shouldn't be using that rent for something else. You should be keeping that rent so you can pay when the repairs are indeed fixed later down the road. But as with the repair and deduct, there is a possibility that the landlord gives you a 3-day notice and then you'll have to fight that. And so maybe that might not be worth it. And oftentimes it is fairly difficult to fight it because you need all of that evidence. So if you don't have all the evidence of you communicating to the landlord and all the photos, it might not be the best course of action because we don't want to risk your housing. And a roof over your head is oftentimes better than, nothing. So, just keep that in mind, and keeping all of the rent safe is very important because at the end of the day, you will have to pay all of that rent. Constructive eviction is essentially a legal term that means that the landlord's action, their conduct was so terrible, it was essentially as if they have evicted me. So that's another option as well. If the conditions are so terrible that you end up deciding to move out, that could be something that you do. The risk here would be that the landlord still goes after you for any of the rent amount that they think you still owe. So if you're trying to terminate a fixed term lease 5 months ahead of time, they could still theoretically go after you for that money, and you might have to fight that, but that is a possibility. So again, really depends on the situation. I don't think it should be your first first choice when you are going through the habitability issues, but it is something that you are allowed to do. The last thing we have on the list is suing the landlord for damages in small claims court. I actually think this is a really, really good one. Of course, it is a lot of work to go through small claims, but you are not in the defensive. You're going to be the one that is suing, right? There's less risk involved. So if you are trying to do this, you should, of course, be on time with your rent, have all of your rent payments current, because when you are suing someone in court, they can also sue you back for what they think they deserve. So if you are behind on rent for 4 months and you sue the landlord, they might start an eviction process on you or counter sue you, saying you haven't been paying rent. So there is risk involved if there are ongoing issues like that. But if there's no ongoing issues, it is definitely something that folks should consider. There is a fee waiver. There are no attorneys involved, so that kind of puts you on a similar playing ground. And there is an advisory court in the different courthouses for them to help you assist in this process. And it is something that folks win on. You'll just have to have really good proof of how long the issue has been going on for and your maintenance request. And your claim in small claims court, what you are arguing is that I overpaid my rent because the conditions were so terrible. And then hopefully, if you win, the judge will give you a portion of your rents back. So maybe instead of it being $1,000 a month, the judge says, oh, you haven't had heating in 5 months. So for those 5 months, you should only have been paying $800. I think that's how much the lacking of heating was costing you. Then you will hopefully get that amount back from the landlord. So that is something that you can do. There is always a potential that the landlord retaliates against you, which is not legal. But like we earlier spoke about, it is possible, and oftentimes landlords do end up doing it. So that is something folks have to consider, but I've seen successes in them. So I'd highly, highly recommend if that is something they are willing to go through. Next slide. It is a slide about any questions. We're gonna put all the questions in the Q&A. All the folks that are chatting the questions, we're not gonna be able to answer all of them if you are putting them in the chat. So put it in the Q&A, please. All right. So next kind of topic is different from the habitability. Oh, one thing I did want to note, kind of connecting our reasonable accommodation we spoke about earlier. When you're asking for habitability repairs, if that issue is causing you concern or like issues and it's related to your disability, I suggest mentioning that on your repair request. So maybe the AC went out, even though it's not like a building code violation. Maybe you wanted to, you let them know, hey, I have really severe asthma and not having temperature regulation is really causing me a lot of harm in my health. You probably will want to have a doctor verification, but you might want to attach that to your repair request to try and expedite it as much as possible. So I do suggest kind of making that connection if it is, there. Okay, so going back to the eviction process, we don't have that much time, so I'm going to make it fast. Unlawful detainer is an eviction process. It all has to start with a written notice. If there is no written notice, they cannot proceed with an eviction process, right? So it starts with a written notice, 3-day, 30-day, 60-day, 90-day. It really depends on the type of tenancy, how long you've been there, or what kind of subsidy is attached to figure out if that notice itself is even valid or not under the law. So if you guys do get this, I suggest that you contact an attorney. You could call our legal services and we would try to assist folks in understanding if the requirements are actually on that, 3-day notice or whatever notice you're getting. Keep in mind that mobile home parks do have different laws. So if you have a mobile home client, then they might have a completely different set of law and different set of rules. So you do have to keep that in mind. And another thing that I often get questions about is the landlord wants to turn off the utilities. They want to, lock me out, change the lock. That's illegal for them to do. They are not allowed to do that until they have completed the proper court process. So proper court process is going to be everything that we're going to talk about in the upcoming slides. So until they finished all of that, they cannot change your locks. Instead, the tenant themselves could call the sheriff's office and show proof that they have been a tenant there. So maybe a lease, any bills that they've been getting to show that I am a tenant, and the sheriff's not going to allow the landlord to lock out that tenant. Next slide. Okay. Once your notice expires, that's when the landlord can start the formal eviction process through the courts. You will typically know that it got started because there's going to be something called a notice of filing that comes in the postal mail. And the notice of filing is not the one that is actually on the slide. That's the summons, but it's going to look fairly similar. It's going to have like the court stamp on it. And it's just a courtesy copy to the tenants to let them know, hey, your name was on a court document, so you should probably be aware of it. After that, that, they have to, of course, serve you with the summons and complaint. And that's going to be the document that's on the PowerPoint right now. So it's going to be that complaint and the actual notice that they're basing it off of. Maybe if they need to attach a lease agreement, that should all be in there as well. So it's going to be fairly, it's like a packet, not just one sheet of paper, and they need to actually serve it to you. So that's going to be kind of what the photo shows. So someone coming to the door of the tenant, handing them a packet saying, you're served, here it is. And then that's when the timeline starts clicking. So next slide. So when you are served, you have 10 court days to file an answer. Filing an answer is very, very important. We do have a LISNIC website where it guides you through the process. It is I think it's like a 40-page document that goes through every single line that's going to be on the answer packet. It is really important to file your answer on time. I always suggest that you try to answer on the last day possible, but if you're worried about the timeline, maybe 2 days before, right? But I don't think you should necessarily do it on the first day that you get the summons, because here's the thing. As soon as you file your answer, the landlord can request a trial date. Trial date is set within 15 to 20 days from them requesting it. So the sooner you file your answer, the sooner the trial date could be. It's not always the case because the landlord's attorneys or the landlords might take some time to request that, but it is something that could happen, right? So if you are able to, I would wait a little bit to file the answer within the 10 court date period. If you do not file an answer, you get a default judgment and then you lose automatically. So you do not want that to happen. And all of the defenses that you have, you do not necessarily have to add all your evidence at the time, but you do still have to put them on your answer because the court's only going to allow you to argue the defenses that you wrote down on your answer. So if you're not sure about something, just write it down just to be safe. Next slide. Okay, getting ready for trial. Like I said, trial dates does get set fairly quickly in eviction court. On the day of your trial or getting ready for trial, you need to kind of consider many different things. I have a couple list of things, right? How strong are your defenses? What are the risks? What do I really want to happen? Keep in mind that if you have any evidence or witnesses for written documents, that's fairly easy. You just have to bring extra copies with you on the day of trial. But for witnesses, a letter from a witness is not going to be enough. You're going to have to actually bring that person with you to trial so they can testify in front of a judge. And depending on, the situation, it might be worth moving out fully before trial to prevent an eviction judgment, because eviction court is really about who has the possession of the unit. So if you no longer have possession of the unit, then they're not going to be able to put an eviction judgment on you. But here's the thing, if you are owing rent or something like that, they could still go after you for the money piece of it, but you're not going to get an eviction judgment. So that might be something that is better for some tenants than others. So you might want to just kind of flesh that out, see what that looks like. And as it says, everybody in the household needs to be out. Everything needs to be out. Drop off the keys before trial if you can. If you cannot drop off the keys before trial, bring it to trial with proof that you fully moved out, a video of the unit, and still show up to trial. Because if you do not show up to trial, some landlords, maybe they don't know that you moved out. They could still potentially get an eviction judgment, and then you'll have to fight that by saying, I was actually out. Might not be worth the trouble. Just show up to trial, bring the keys, bring proof that you actually moved out, and hopefully that prevents an eviction from going on your record. Next slide. In your day in court, they're going to call attendance. In Sacramento County specifically, they do allow, and it is a mandatory settlement conference, so that you kind of go out into the hallways. You don't really get a room, but you have an opportunity to try and negotiate. Couple tips, I'm going to try to go through fast because I only have 5 minutes. Be on time. Plan to be there for the entire morning or the afternoon, depending on when your court time is. Bring copies, at least 3 copies each of your evidence if it is written documents. And if you lose at trial, you will be locked out within a week or so time. You will get a sheriff's notice on your door. If you win, then you're gonna owe the rent that you haven't been paying. So it's important that you are actually holding on to that if you are planning on fighting an eviction in court and hope that you are gonna win. Next slide. I'm not going to necessarily read through all of these, but I have, I believe, 2 slides, this one and the one after, if you can get to the next one as well. These 2 are just kind of talking about what do you need to think about when you're trying to negotiate. So if you wanted to take a look at these slides, I think it will be really helpful. Next slide. So if you lose, like I said, you're going to get something called a notice to vacate by the sheriff. It's going to have an exact date and time on when they're going to show up to your door. Typically, you get around 5 days for you to move out once the sheriff's notice is posted. So you need to take a look at what it says. There is a possibility that you can ask for something called a stay of execution to get more time. There are packets available at the courthouse's self-help advisory clinic that you can fill out. Stay of execution, it was one of the questions that we had, is can you ask for a reasonable accommodation to get more time to move out, even if you got a judgment? Yes, you can. That's called a stay of execution. If you do a stay of execution, you do need to pay for the extra days you're hoping to stay, but the judge will be the one to decide, does this person actually need more time? It is really helpful if you can say, I have a place lined up that I can move into in 10 days. Hey, judge, can I get 10 more days? That is probably going to be a better way of doing it rather than going, I need 10 more days. I have nowhere to go. That one is very shaky ground just because a judge is going to be thinking, how is 10 days going to make a difference here? That's why you need to have a little bit more meat there. So you need to be able to explain, how are these extra days going to help you? What do you have going on in your life that the judge should take into consideration? So that's all needs to be in what is called the stay of execution. Other than that, you could again try to negotiate a reasonable accommodation with the landlord themselves to say, I need a little bit more time. So those are kind of your 2 options at that point. Next slide. I think I'm done actually. Very fast. Can we go to
Yeah,
the next? Oh,
yeah, I would love to.
oh. So I did have a slide just with our legal services information. Oh, here it is. So we do a lot of different things, not just housing. So these are all of the different things that we do to get them connected to us. We have all our contact information for our local-ish offices, and they do need to call early. We are not able to get through everybody that calls. So the earlier they call, the better it is going to be for them to get through our intake list. All right, that is all from me.
That was fantastic. Well done on time management. I appreciate it so much. Lots of applause. So here's my offer. If you dropped a question in the Q&A, Minyoung and Avantika, are you able to stick around and answer those live? Because some folks have been waiting since like 10:15 for an answer.
Yes,
Yeah,
I
look,
am
Yeah.
able to.
some Q&A, yeah.
Thank you so much. I really appreciate it. I'm going to pop open the Q&A and go right up to, let's see. Okay. I wanted to make sure we got to one specific, and it looks like you did. Erica asks, it's my understanding that a landlord, property owner, or manager cannot deny an applicant with a criminal history that never resulted in a conviction, and that this type of denial based on a record of criminal history, but no convictions, is a fair housing violation and discriminatory. Is this true? And can you speak on this, please?
I can go into that a little bit. Like I mentioned, we do have a toolkit on that. My understanding of the current law is that it is when a person has just an arrest but it's not a conviction, they do not have a criminal record. So, and that California law would protect that person. But I can't report to you that I've seen those types of situations of potential discrimination be actively accepted as complaints, because I think it would depend on the facts of the circumstances of that particular situation and what the documentation was. But to me, if it's not a conviction, it's not a criminal history.
Great. Thank you so much. We'll get to the next one from Vivian. If the tenant offers to pay for modification, will the landlord need to approve if reasonable? I think you said yes.
That
Yeah.
part, yes.
Yeah. Can a landlord require a tenant to purchase the requested modification or require the tenant to pay an outside handyman to install the modification?
Yes, in the case of a modification, because as we kind of went over in a modification is physical change to the unit, and the logic behind getting the tenant to pay is that the assumption is that the future tenant may not want that same modification, so they're asking the tenant to pay. Then at the time of move out, the tenant will take it out and restore the unit, and then it'll be just like the unit was when they moved in. That's kind of the idea. There are referrals in Sacramento. I don't have them offhand, but for places that do assist to look for funding, if they're kind of slightly more expensive modifications to the unit.
Okay, thank you. Let's see. If a tenant requests an RA for an ESA, emergency emotional support animal, that is a pit bull, but the homeowner's insurance does not cover that breed, can they deny the request?
I would
Uh,
say possibly. I don't know, Avantika. That's a hard
yeah,
one.
I think insurance issues are very
Mhm.
nuanced. The prompt said homeowners insurance, so a homeowners insurance policy would be in effect if it was actually a home. So single family homes can be under exempt from FEHA in certain circumstances if there's only one border. It's called a border under California law. So you might have to reach out to one of us and figure out if this is actually a protected circumstance, or whether they're under one of those exemptions. But backing up a little bit to your question, it could still be an ESA, right? But there might be kind of like an interactive process needed about, well, this isn't needed on the basis of, so I have had pit bulls like approved as ESAs and approved by housing providers in the past. So
Wonderful, thank you. All right, do housing VAWA protections apply to clients in unsubsidized units?
good question. So there are two kind of levels. So in subsidized units, there's higher levels of protections because the Federal Violence Against Women Act applies. In California, like the rest of the housing providers that are not subsidized, except if it's a low income tax credit housing, which may also have its own protections, most of them, as far as I understand, have those California rules like 1946.8 should protect them. And that has, the right to not be penalized by being kicked out if you call law enforcement, those types of protections.
Wonderful, thank you. There's a couple of questions in the Q&A about flyers and recordings. Yes, you will get all this information in your email, including the answers to the questions. We will just stay for another 5 minutes to respect everyone's time and schedules. If your question is not answered here live, Minyoung and Avantika will answer these via email with me, and then I will make sure to get these out to all of you so you do get the responses as well. Let's see. Regarding assisting clients with mental health issues that make self-advocacy challenging, how can I, as a case manager, best assist clients in reaching out to LISNIC to request assistance? When I call regarding a client, they typically want the client themselves to call. Is there an ROI process? Such an excellent question, Joanna. Thank you.
So if the clients are having like mental health difficulties that make them difficult, make it hard for them to call on their own, we do sometimes allow our, other advocates to put their name on the list. That's totally okay. You do not necessarily have to have the client themselves, come and do that process. We do sometimes maybe like a family member calls on their behalf and puts their name on the list. But our first conversations, we do have to talk to the client. It does not matter if you have an ROI, unfortunately. We need to make sure that the client themselves wants our help, and we need to have that first initial conversation with them. So getting them on the list, yes, you can do that on their behalf, but the first conversation we will have to have with the client themselves. And then if the client gives permission for us to speak to you, then 100% we can continue speaking to you as well. Hopefully that answered the question.
Thank you so much. My goodness, we still have quite a few. Let's see, when people are emailing CRD, they are getting emails back to alert them that they will get a response in 6 weeks. Where can people turn when CRD and LISNIC are so far behind? Thanks, Sherry.
That's a hard question. So for everybody, I don't know how the CRD process goes. I do know that it takes a long time. And even for getting in touch with all these nonprofits, it takes a long time. I totally understand that. And folks do want answers right away. And it is impacting their lives right now. So I totally get it. But for your information, our legal services, we get over 300 calls a day just in my office in Sacramento. We have a limited intake spot because we have a limited staff and we do a lot of work. Yeah, 300 calls. We simply do not have the capacity. So that is honestly the reason why it takes us so long. And I assume it is kind of similar for other organizations. So I don't really know what the answer to that is, but looking for all those resources, doing everything you can. That's all we can always ask from our folks. So sorry about that.
No worries. Thank you so much. We've got time, I think, for one more question. I want to follow up about the refusal for accepting third-party financial assistance from a valid organization. What can a tenant do to ensure the leasing office follows the government code 129550?
I feel like this might be a better question for Avantika.
Sorry, could you repeat that question? I was
Sure,
chat.
no worries.
Okay.
I want to follow up about the refusal for accepting third-party financial assistance from a valid organization. What can a tenant do to ensure the leasing office follows the code 1295?
I'm not sure if they're referring to SB 267, which regards the alternative credit verification. Because 12955 in subsection O and P, does that have the protections for income that alternative income needs to be accepted? That does include third-party rental assistance. For example, Section 8 vouchers. And then in Sacramento, we did have like a program post-pandemic that was giving out rental assistance as well. So you could reach out to Project Sentinel or LISNIC for information. You could Google SB 267 and basically look up like a 1 to 2 paragraph summary on online sources, and then send that through email. Like, hey, housing provider X, I'm not sure if you're aware, there's this new development in the law in California providing that you are required to provide an alternative means of providing proof of credit to tenants who have income supports coming in. Here's a summary of this law. Is there a way you can work with this tenant to give them an alternative way of demonstrating their credit, and see what their response is?
Thank you so much. And that is time. It is 11:40 a.m. For those of you that have stuck around, the 200 of you still with us, thank you so much. Thank you for allowing us to take just a little bit more of your time. Again, I am going to circulate any unanswered questions to Min Young and Avantika, and I will be sure to get those out to you via email as well. Thank you for the hearts and the applause. We love it. Please
Thank
be
you
sure to
so much.
please be sure to complete the survey on your way out. Leave your feedback on ways we can better improve. And next time we'll have a little more time. Thank you again, Avantika Minyang, Project Sentinel, and Legal Services of Northern California. And of course, everyone on the call, thank you for all the work that you do in the community. And we'll see you next time.